welcome back into the show. It's time for our Law and You segment sponsored by Gig and Jancola. We've got attorney Michael Gig here with us now. Good morning.
Good morning.
Yeah, Mike, tell us the types of law that you practice. I know Chris can't be here, but he covers a different set as well. Yeah,
Chris does most of our personal injury, workers' compensation, and Social Security. I do a lot of our estates, estate planning, and real estate.
Yeah, we were thinking of some different questions, of course. People are able to write questions in here on the show. You answer them, but you said your receptionist thought of one that, you get.
Yeah.
And I thought, hey, this is pretty good. It's how do I handle the bills of my loved one after they die or they pass away? Yeah, we kind of handle this, we see this a lot because credit card companies are coming, but maybe just bills in general look different.
Yeah, this is a common question. People get, especially if they know they're named as executor in someone's will, a lot of people, get kind of taken over by this, and it's very overwhelming. But the first question I do hear is like, all these different bills. What do I do? And first thing I tell them is the most important thing, and I've mentioned this in previous shows, is any of these bills of the deceased person are not your personal liability. Okay, some people, for whatever reason, think, well, if I get sworn in as executor, I'm now responsible for all of it. The only thing you're responsible for is if there is money or assets to pay these bills and they're legitimate debts, you have to make sure they're paid. Okay, the only way an executor could get into trouble is, they take the money and don't pay these bills. So if as long as they do that, there's no personal liability. The other main issue, or the main thing that people have to understand, is they can only come after assets or money of the person's estate, okay? So anything that they maybe held jointly, like husband and wife, we've talked about that in previous shows. If they maybe put their son or daughter on the deed of their house, those are jointly held assets. They can't force you to sell those to pay these debts. Usually the first debt is the funeral bill. Okay, some people, they've planned for it. Maybe they had an irrevocable burial trust or something to pay for it. They had life insurance to pay for it, but some people don't. So that's usually the first bill that has to be paid. Some people, they come into my office and they said, oh, we've already paid it. I paid it out of my own money. So initially I'll say, well, once, if they have money in a bank account, the deceased person, once you get sworn in, you can get into their, close out their bank account, pay yourself back, because of course that's a debt of the estate. But, and then there's kind of a pecking order of what gets paid. So the funeral is usually the first to get paid. Any of the costs of administering the estate, that could be everything from the attorney's fee, the executor can take a fee. When you get sworn in at the courthouse, you got to pay probate fees. Those things all come off the top first as well. And then of course, another issue that you see a lot is, and this could get tricky, is like if there's a mortgage on the person's house or any of their real estate. Obviously that can't get delayed too long because you don't want it to be foreclosed on or something. Those can get into some tricky issues, especially if the person that passed away didn't really have any cash to pay it. So that can get into maybe until they can get the house sold, the executor or family members might have to just pay that mortgage for a couple months just to keep it from a foreclosure action. So there's unique situations like that, but the biggest thing is there's no personal liability of any of the beneficiaries. It's the estate that has to pay it, and they can only come after assets of the estate to pay these bills.
I know you've mentioned too, just kind of a safeguard, making sure your assets are in both people's names if you do have a spouse living.
I mean, the big thing is like with a spouse. I mean, sometimes people, if it's people that have been married for 40, 50 years, the majority of people have everything in joint names, bank accounts, real estate, cars, stuff like that. They have each other as beneficiary of accounts. But, second, third marriages, for whatever reason, real estate's just in one name. Bank accounts are just in one name. So I always tell people, it's not my business why you have it that way. It helps estate-wise if you have it in joint names, or put a child on a bank account once you're maybe a widow or a widower. That can help, but especially with spouses, if you can have it in joint names, that can help as well. And then, those would not be subject to some of those claims.
Yeah, little things to look out for. If you find yourself in this situation, or maybe you just want to kind of proceed with caution, which is always a good thing to do, and consult an attorney, what's the best way for people to reach out to you guys?
Yeah, call us at 946-1606 or through our website at gig-law.com.
All right, it's that easy, and keep submitting those questions. If you've got one, we'll answer it here on the show every Tuesday and Thursday. Thank you, Mike.
Thanks.
Well, coming up, it's time to boot, scoot, book.